Again, welcome to my Protecting What and Who You Love estate planning seminar. I'm recording in hopes that this will have an opportunity to be heard by more folks than those who may be live with us today. But thank the couple of you who are here now and the few who will come in before we're finished for joining me. I shared with one of our attendees that I didn't expect a great turnout, but that I wanted to push myself and make this information available at no cost to the community, easily accessible. Every opportunity that I get to share about estate planning, I really want to do it. I really want to get the word out to the people so that we understand what our rights are, so that we understand how we can protect ourselves, we can protect our legacy, our loved ones, really from governmental involvement and losing control in assets. Some of us may be control freaks anyway. And so the idea of not being able to know what's going to happen when we're no longer here can really cause fright and alarm. And there are things that we can do and put in place to make sure that we have covered as many bases as we possibly can as human beings for our loved ones. And what you'll see briefly is that estate planning is not just for when you die, but it is about your life and your estate now, even while you are living. There are so many things that can happen in life that we don't have control over, that we may have to live through, but we may not have all of our wits about us. And so we want to make sure, if God forbid that were to arise in our life, that we've already designated the people we want in place and the what of what we want in place, okay? I wanted to raffle, it's not really a raffle, I wanted to see if we can do a game really quickly and see if I can give something away. So I want to give away a Starbucks gift card. I'd love for you to participate. This is a Kahoot. It's only 10 questions. So I want to invite you to party with me and celebrate with this Will Palooza game. So let me see if I can share this. And I'll explain it if you've never done Kahoot before, how it works, okay? You should maybe hear a little bit of volume, but not a ton. Okay, so are you able to see it? Hopefully you can. Hold on, let me see, I see.
Yeah, we can see it.
Put it in, thank you, thank you, thank you. I see somebody in the waiting room, so I'm gonna try to, oh, they're gone. Okay. All right, you can see the screen and you can hear it a little bit? Yes, 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 I heard somebody anyway.
Yes.
Okay, so it's Kahoot. You have to go on your phone or other device, other one that you're probably not on, to join Zoom, and you're going to go to Kahoot, KAHOOT.IT, and you're going to enter the game pin, which I will copy and put in the chat too. Once we've had a couple people join, let me see if it'll let me copy it. Oh, it's copied, okay. I did put a link in the chat. Hopefully that can get in on that. This is supposed to be a lunch and learn. I don't know if you have any lunch. Hopefully you do. If you don't, that's okay. I have, what do I have? I have my soda here, and this will be my lunch for now until after, and then maybe I'll have my paralegal come and help me order something. I can't even order on my own. All right, come on. I see some folks coming in. I see you there. Jonah, Micah, Stacy. If anybody else wants to join, you can join in. I am going to, our winner is going to get a Starbucks gift card. So I will give it another 30 seconds. Saw somebody else come in. Thank you for joining. I'm happy that you're here. Okay, let's go. We're going to start. I'll read the questions even though I think that you can see them. And okay, here we go. Will Palooza trivia. It's okay if you don't know. But let's see what you do know. Okay, everyone under the age of 18 should have a power of attorney, true or false? You pick, oh, I don't know if you can see. True is blue, false is red. Sorry, it's like what, 10 seconds? I can't speed it up. Boom. Okay, 4 folks say true and 1 person says false. The answer is true. Everybody over the age of 18 should have a power of attorney, especially if that person who's over the age of 18 is driving, is out about living their life like an adult. God forbid they are in an accident or something like that. Somebody should be appointed to step forward for that 18-year-old. Many of us who have children, we think 18 is not grown, but the world says it is. Next question. Oh, first, let's see who's on the scoreboard. Jonah, you're number 1. We see Stacy, Bonnie, everybody. All right, next question. 2 out of 10. What do you call the person making or signing a last will and testament? Making/signing. A last will and testament. Administrator, decedent, testator, or a trustee? What do you call them? Just give me your best guess. All right, everybody's got their answer, and we see everybody gave one of the answers just about. The correct answer is a testator. So the testator is the person who signs the will, who sets up the will. And if you did your last will and testament, you would be the testator. Okay, next question. Let's see. Well, first, let's see who's on the scoreboard. Jonah, still at number 1. It's pretty smart there. But I see you moving up, Stacey. Okay, approximately what percentage of Americans do not have a will? 45%, 60%, 20%, 80%. What do you think? We hear the answers coming in. All right, we got a little bit of all over, but the correct answer is about 60%. I think recently it's a little bit above it, but not quite 80. Okay, so it's about 60% of folks do not have a will. All right, next question. Oh, for a scoreboard again. Okay, Stacy, we see you moving on up. Number 1. Let's go. Next question. All right, number 4. What is the legal process that a family will likely go through after death of a loved one? Okay. Probate, litigation, superior, or surrogate? Boom. Probate is the correct answer. That's right. All right, let's see what our scoreboard is doing. Stacy holding strong. We see you, everybody else. Mike, I see you making moves back on the scoreboard or up on the scoreboard. All right, number 5. An advance directive is also known as a living will. True or false? As a living will. It's true. It is true. It is also known as a living will. Wow. All right, Stacy still hanging in there. Let's go. And she has a streak. You're on fire, girl. Okay. Next question. Only wealthy or real property owners need a will. Only wealthy folks or real property owners need a will. You guys got that right for the most part. The answer is false. Everybody needs one. Once you get become an adult and you begin to own things, even when you don't own things, but you have a life and you have business, you probably need a will. Okay. All right. Scoreboard. Hey, not too much changing, but you guys are doing really, really good. All right. We're almost to the end. Number 7. The person or persons for whom a trust is established for. Trustee, trustor, beneficiary, or settler. And I know you're like, I don't, how do I know this? I don't know, just guess. Oh, you did know. Most of you got this correct. The answer is beneficiary. Let's see the scoreboard. Yeah, let's go. Stacey has the highest answer streak of 5. Awesome. Okay, number 8. We just got 2 more to go, y'all. Okay, a healthcare proxy is a person you trust to speak on your behalf for healthcare, or a document in which you identify your healthcare wishes. Yeah, so this is a bit of a trick question. So I see you was split a little bit. Um, on your document, it will say it's your healthcare proxy, but the truth is it's the individual that you are appointing in that document. So the correct answer is the person you trust to speak on your behalf for healthcare. Good. All right, let's look at the scoreboard. All right, we have two more. Stacy's still in there. I see you moving up, Bonnie. Okay, true or false? Having life insurance means you don't need a will. True or false? False. Good. You guys got that correct. Life insurance, sometimes people think, oh, well, life insurance is going to bypass probate. And so that's good. But there's so many other things that life insurance doesn't cover. And so the answer is false. Next. Okay, Stacy's still there. Bonnie has moved on up. Everybody else is hanging in there. I see you, Sydney. I see your numbers going up. All right, and then our final question. Thank y'all so much for indulging me. I'm excited. Let's see who our winner will be. What estate documents should everyone have? A will and advance directive, a will, trust, and power of attorney, will, advance directive and power of attorney, or will and power of attorney. This maybe is a maybe this is a trick question too, but let's see. Yes, so the answer is a will, advance directive, and power of attorney. However, everybody that said will, trust, and power of attorney, you really should win too. But the baseline documents are a will, advance directive, and a power of attorney. But yeah, I think everybody should have a trust also. But if the question is, what's the most reachable? And those are those three documents. So that was the correct answer. So let's see who our winner is. On the podium, in third place, Jonah. Good job. In second place, Stacy. And our number one, can you believe it? Bonnie. Oh, congratulations, everybody. Mike and Sydney are runners up. Thank y'all so much. Let me stop my share. All right, I got a lot going on my screen here. So thank you, everybody. Bonnie, if you can direct message me your email, I will make sure to send you your Starbucks card as soon as this ends. So for the rest of you who are here, if you would just indulge me for a few minutes, I'd like to give you a presentation on estate planning. We will be done this in short number, but I think it's really important information that you can get for yourself, that you can share with somebody that you love. Many times we think that we know and we think that we understand what estate planning is, what may happen when we or one of our loved ones die, but we don't often know. As a estate planning and probate attorney, many times families come to me after their loved one has passed away, and they find out that they don't have a clue what to do next. And so some of what we do with estate planning informs our loved ones how to take the next steps without us. And we make it so that they don't have to think through everything, or we've already done some of that pre-thinking and pre-planning for them. Okay, so I'm gonna try to share this presentation. I can't guarantee whether I'm going to be able to see you in the chat once I go into presentation mode. But by all means, if you have questions, you can unmute yourself and ask. Feel free to interrupt me, or you can put them in the chat and it may jump up for me, okay? So today's presentation is Protecting Who and What You Love, Valentine's Day edition. Tomorrow is Valentine's Day, so happy Valentine's Day weekend to everybody who celebrates. And even if you don't, this is a day of celebration for you, because out of my heart to you, and hopefully it will help you for the folks and things that you love. Okay, so let's talk about it. Hopefully I can. Okay, here we go. So we talked about this in our Kahoot that we just did. How many people die without a will? Statistics say, this is a 2023 survey, over 67% of Americans don't have a will or will die without a will. And look at this percentage for the Black and Brown community. Over 75% of us do not have estate plans. And this causes for so much more confusion than I think we know. And that's probably why the percentage is the way it is. A lot of this, I believe, has to do with fear, fear of maybe if I do this, I'm going to die sooner, or I don't want to talk about it. I just want to pretend like it's not going to happen. Or I'm afraid of what the investment financially may be, and so I don't deal with it at all. And little do we know that we are often creating financial headaches and heartache for our family in the years to come. Okay. Again, many believe that it's for the wealthy, and it's not for everyone, but it certainly is. And here's the part that really, really frightens me for people in general and my people specifically, is that the state does have a plan if you don't. So just because you have a plan doesn't mean there's not a plan in place. And it's very likely that the plan that is in place is not one that you would have selected, okay? So this is why estate planning matters. It ensures your loved ones are protected and your wishes are followed. It avoids unnecessary legal battles, because if your family members don't agree with one another, they will end up in court if you haven't given them instructions. We are in Mount Holly, and so it's a noisy little town. So forgive the background noise, okay? Also, it will then reduce stress and financial burden on your family just because you've written some things down. So even if you say, well, I don't have any money, and all I have is my house, or all I have is my car, at the end of the day, those assets matter, and it can cause a lot of stress and anxiety and even financial burden on your loved ones if you haven't indicated what you would want to happen if and when you're not here, okay? And also for those of us who have a little issues with always wanting to be in control, it allows us to control our legacy and what will happen when we're no longer here, okay? Again, if you have any questions and what I'm saying, let me know, put it in the chat, or just interrupt me, okay? So I just wanted to quickly touch on what we call intestacy laws. Intestacy intestacy in every state, but in particular in the state of New Jersey, we're going to talk about that real quick. But what that term means is no will. So when someone dies with no will, they are said to have died intestate, okay? So the intestate or no will laws will determine, in the state of New Jersey, and every state is a little bit different, but every state has these laws, will determine what happens to your stuff when you die if you have no will, okay? So just like a real quick touch on it, if you are married and you have children, but those children are not all from each other, right? So this happens in blended family situations, even if the family has actually all the way blended, but there's no adoption that takes place. So for instance, if there's a spouse, a wife, or a husband, and there are stepchildren in the household, and those stepchildren have not been adopted legally, then this applies, okay? So if you're married with children and there's at least one that doesn't belong to both, the spouse gets the first 50% of the estate. I'm sorry, the first 50,000 of the estate, and then half of the remaining 50,000 or whatever the remaining is. I know that sounds like a little complicated, but it's just important to know, because a lot of times people think that my spouse is going to get everything, but they have a blended family or they have children that exist from outside of the relationship. And we should all be aware that that is not the case. Okay, so the first 50,000, and then whatever remains, half of that goes to the spouse, and the remaining part of that is split between the natural children of the person who died in equal parts. Okay, if you're married and there's no kids, the spouse gets everything. Okay, if you're unmarried with children, the children inherit in equal parts. Sometimes this is complicated, right? I have siblings in my office all the time, including right now, who don't agree with each other, and there is no will. And so where do we find ourselves? Dragged through the court system, often having to wait for a judge to say what's going to happen, because these adult children will not agree with each other. And even if they got along when their parents were living, many times when money is an issue, families break down. and relationships break apart. And just having a will could have fixed it, okay? If there's no spouse or children, then parents inherit. If no parents, then siblings. If no siblings, then whoever remains in the family, okay? If the state can't find anybody, what do you think they'll do? They will take your assets. So whatever you had, houses, cars, money in your bank, it all goes to the state of New Jersey if nobody comes in. I think I see a question in the chat. Let's see. Oh, no. Okay, I see what that was. That wasn't a question. All right, moving on. All right, hopefully I can move on to the next slide. All right, let's see. Okay. These are the must-have documents. We talked about this in our Kahoot. A last will and testament, which will specify who inherits your assets, but it also appoints whoever's going to carry out the business of your estate, okay? If you have minor children, it will also appoint who you would want as a guardian. Now, in the state of New Jersey, you have to take additional steps, but your executor will know who you want as a guardian, and they will take those steps to put that person in place. A durable power of attorney, this is something that works while you are living, okay? And you give somebody authority to act in your stead if you don't want to act, or if for some reason you're living but you are incapacitated, okay? That is a power of attorney, often called a durable power of attorney, okay? And then the healthcare directive, this is like a power of attorney, but it's just for your health. And it's also called a living will. And in this document, you're going to state what your medical wishes are and who your healthcare proxy is, which we also talked about, who can make decisions on your behalf in accordance with what you've already laid out, or for your best interest if you haven't said anything about whatever the particular health medical issue you're facing, okay? And then beneficiary designations, even though that's not a document, it's important that if you have life insurance, 401ks, and even your bank accounts, that you have identified a pay on death beneficiary, okay? If and when you do that, whatever that asset is bypasses probate altogether, and it goes straight to your beneficiary. So that is an essential part of your estate planning. So think about any of these things that you may have and make sure that you already have a pay on death beneficiary established. And if by chance who you have is no longer living, who you have named is no longer living, or you don't want them to be the beneficiary anymore, now's the time to change it, okay? All right, next slide. Who will handle your affairs if you can't? This is why we talk about you're alive, but you can't handle your affairs. Having a durable power of attorney in place and a healthcare directive for the power of attorney part, like God forbid, you have a mental change in status that happens suddenly, right? If you don't have a durable power of attorney in place, your family has to go to court to be appointed as your guardian in order to make any sort of decisions, not only financial decisions, but all of your decisions. They have to go through a court process. However, if you had a durable power of attorney in place before any sort of sudden onset of mental incapacity or physical incapacity, then they can step right forward and stand in on your behalf. Essentially, this is the same for a healthcare directive. Healthcare directives move a little quicker because it can be done at a hospital, but it can delay decision making, and it makes sense to have this in place. Some of you are really, really young and you think, man, that probably doesn't apply to me, but it does. If you're over the age of 18, it is certainly something you need to think about. It can be a simplified document, but it is something that you should have, okay? Our next slide. And certainly, again, any questions, put it in the chat. Should you consider a trust? Yes. And why? My number one reason that I tell folks that they should consider a trust is it avoids probate. Probate is the legal process that families often have to go through, even if there is a will, but definitely if there is no will. And this means whoever the person is that is standing in, whether it's your executor through your will or somebody in your family who wants to be appointed as an administrator, they have to go to the surrogate's office and make an application and take a death certificate and go through all of the process of being verified and qualified by the court to act on the behalf of the estate of the one who passed away. If you have a trust and it's drafted properly, They don't have to do that at all. Your trustee steps forward and does what you want them to do without the involvement of third parties. Okay, so that's my primary reason that I say you should do it. Of course, it can protect minor children and make sure that nothing goes to them too early, because a will may say, I want $10,000 to go to my children, but they are, I don't know, 12 or even 18. And maybe at 18, they receive it, but they don't have the wisdom and maturity to deal with that amount of money. A trust can really instruct how the distribution should happen. So you can say 5,000 when they graduate from high school, and 10,000 when they graduate from college, and 30,000 when they purchase a home, for example. Okay. And it also can manage your assets in the event of your incapacity. Somebody can come straight forward and do whatever needs to be done if you're living, but you can't act on your own. Okay. Next slide. This is just to clarify for you what a trust is. I know it's a buzz term, and especially on social media, you hear people talking about it often. You may ask yourself, what even is a trust? It is simply a writing. It's an agreement, just like a will, just like a power of attorney or an advanced healthcare directive. In this document, you get to set up whatever your wishes are and who you want to do it, and they can go into effect immediately. You can take a copy of this document and go to the bank and open a bank account and start saving money, or whatever you would like to do. You can purchase property in the name of your trust. You can own property. So if you already have property, you can put property in the name of your trust. So it's an awesome vehicle that is established through a writing. You who establish it are the settlor or grantor. The person who will carry it out is the trustee. And the people, like you said in the cahoots, who receive the benefit are the beneficiaries, okay? And there are two different kinds. There's a revocable and there's an irrevocable. Revocable is just like it sounds. At any time, you can rip it up, change it, throw it away. Irrevocable is a little bit more complicated because it has its own tax ID number, and it owns whatever you put in it completely separate from you. So now what you put in your irrevocable trust, like your house, is no longer a part of your estate. Creditors can't access it. And a lot of times people use it for that reason. And if you need long-term care in the future, Medicaid cannot count any assets that you have in an irrevocable trust against you, and they can still qualify you to receive benefits for long-term care. Okay. It can get really complicated, but I'm just saying, like, the light touch on it. And I'd love to talk to you in depth about it if I am piquing your interest. You can always book some time with me so we can talk about it. Okay. I'm not going to spend a ton of time on this because we already talked about it, but it is important to do this if you have minor children and you want to make some sort of provisions for them and set up who will be their guardian, who will be making decisions for them, who will be caring for them when you no longer can, okay? And we're nearly at the end. This is some of the ways that you can get started now. I recommend that you start making a list of your assets and beneficiaries. Again, sometimes when we're living in our life and we're living about in our estate, we don't always think we have anything because we have not counted it. So I recommend that you just make a list, even if it's in your phone, in your notes on your phone, and make a list of what do you have. It will include things like your bank accounts. Do you own a business? Do you own a vehicle? Do you have a house? And even if you're only renting, that is a part of your estate, because when you're gone, if you're in the middle of a lease, your loved ones have to deal with unraveling that or winding it down and getting back your security deposit and all of your other personal assets. Maybe you have a watch collection, or maybe you have some valuable electronics. All of these things matter and they are a part of your assets. So start a list of your assets and who you would want to have those things. Maybe if you have a valued collection, there's somebody who's really close to you who's always admired it. Like, I have shoes. I have people in my life who really, really like my shoes, and I would love to give them to them if I'm no longer here, right? So those are things that I recommend you doing even before speaking with an attorney, okay? Choose your person. Who is your person or people? Who do you trust? Who would you trust with your life? Who could step forward on your behalf? This is who you would name as your power of attorney, your executor, your trustee, or even the guardian for your minor children. Do you know who those people are? I can't tell you how many times I've had consultations and conversations with folks who know they want an estate plan in place, but they never thought about who is their person. And they say, hey, here's all the stuff that I want to happen with my assets, but I don't have any idea who I want to appoint. And I have to send them home to do homework and find out who is your person, who is your number two. So if you don't know, I encourage you to decide that now. If you're in betwixt and in between, and you say, I have like three folks in mind, then I would say, get your three folks, write them down. Maybe one is better with money and one you trust more with your health. That's okay. So make that list. And also, I also recommend having a second person for each one of those positions. Okay. Just because life happens and we don't always know if that person that we appoint is going to be available or is even going to want that appointment. So I recommend that you have a one person and a two person for every position that you may have or need in your life while you're living and then after you've gone. Okay. And then, of course, I encourage you to meet with an estate planning attorney to draft these documents for you first, to consult with you, to think through your life and your legacy and what you have in place. Some of you are young and have businesses. Do you have an operating agreement? Many people, because you can just go online and start an LLC and now you're official, but you never put your documents together. So even your operating agreement is a part of your estate plan because in the state of New Jersey, there's a tight timeline on what your loved ones can do with your business after you've died if you have no operating agreement and you didn't address what happens after your death and you're the only owner. Do you have an operating agreement in place? What do you want to happen to your business? Do you want somebody else to step forward? All of those things are things that you can talk to an estate planning attorney about so that you can plan for your life, okay? You want to keep your documents updated and stored safely. As it relates to updated documents, I recommend every 5 years or so you look them over. If anything major happens in your life that changes, somebody dies, you buy a new property, you win the lottery, it is a signal that you need to look at your estate planning documents that you already have in place, or if you don't have them in place, get them in place, okay? And then you need to store them. Sometimes people think that your will and all of that gets recorded somewhere. It doesn't get recorded until after you die. So it's very important that you keep it in a safe place and you let your number one and your number two people know where that place is, okay? If your loved ones don't have your original will when you die, they cannot start probate. They have to go through a court process. The court says, we want the original document where we can see the ink signature. And they check it. They run their fingers over it, all of that. So it's very, very important that you keep your original documents somewhere safe and that your people know where that's at. I just recently in 2025 started giving people who come to Betner-Gray Law Office as a part of their estate plan. And I know somebody's on here who got one from me. So because I just started doing this, I'm going to gift this to you as well. I just started gifting a fireproof package, safe, for everybody's who gets an estate plan with me. It kind of looks like a fabric portfolio. I didn't even think to bring it in here because I would show it to you, but a fabric portfolio, but it's fireproof and it's awesome. And I think it has a combo lock on it as well. So I recommend something like that if you don't have a real safe, something that will keep your documents safe in the event of fire or something like that. And of course, if you have a safe deposit box at your bank, you could certainly do that. But more and more as the days go by and this new administration in place, I don't know if you could ever trust banks, but I'm feeling more and more wary about that. So I kind of think that you should keep it with you in a safe place in a fireproof sort of package, like what I'm talking about. Okay. And then talk to your loved ones. Especially in the Black and Brown community, we tend to not have these conversations, but have the conversation. I want to let you know that I'm available also I'm available as an estate planning attorney to do these sort of seminars and webinars for your loved ones. I do them at no cost. Why do I do it? Because I am extraordinarily passionate about getting the information out there. While this may work as a marketing opportunity for me, that is not my primary goal. My primary goal is to educate my folks, right? As attorneys, we are legally required to do some pro bono and some volunteer work. The court has to require many folks because they won't do it on their own. But there are some of us whose hearts are motivated to share information and to do good just because good has been done for us, just because I have had the opportunity to learn and I see what happens to families who don't know, who don't take advantage of these, what seem like just pieces of paper, and how families can fall apart, how our community at large loses so much wealth because of what we don't know. And when we do know, what we don't implement. So I am very passionate about this. If this is something that you would like for me to do a presentation for you and your loved ones, let me know. Reach out to me, email me, and I will by all means do it. And yes, thank you. I see a question asking if I will share the slides. I absolutely will share it with anybody who is on this and anybody who watches this later and sends me an email and makes a request. I will happily share it with you, okay? And let's see, what is our next slide? This is one of the primary inquiries, and we're almost at the end, everybody. People want to know, how much is it going to cost me? How much money am I going to have to spend? And I understand that, and it is a fair question, right? But I love to start with this first inquiry, which is a question, answering a question with a question. Here's the inquiry. What is it worth to you and your family to eliminate probate or confusion when you are no longer here? And the truth is, if you really, really think about it, that you can't put a price to it. Okay. So it really is priceless to help your family not have to add anxiety to grief. I'm actually dealing with this right now with a loved one who is very, very close to me. And as it was coming to be the time, yep, I saw another question in the chat and I'm going to answer it. Who's dealing right now with having to do probate shortly after her loved one has passed away. And she kept saying to me, I get anxiety. I feel like I'm going to have a panic attack every time the topic of probate comes up. I'm just overwhelmed. It's so stressful. And I want to encourage you to do this and think through this, despite what the upfront investment might be financially, because what the blessing that you give to your loved ones on the back end, you can't put a number to it, okay? Now, to actually give you some numbers to put in your head, this will vary from attorney to whether you do an online platform, which, by the way, I didn't say it in this presentation, but I often say it in other presentations. Online documents, I don't recommend them. Why? Because you are not an attorney and you will just take the document, sign it, and say, this is perfect, this does what I want it to do, but you really don't know if it does. And so at a minimum, if you're going to use online documents, then by all means, please still consult with an attorney first, consult with the attorney. And if you say, okay, I'm not paying that attorney, I'm going to just do it, at least you have the information, because people are getting these documents all the time. Like Susie Orman, she's making millions of dollars on often poor communities, and she is not an attorney, and doesn't know you. She doesn't know what your estate is. She's not advising you about yours. She's saying, hey, buy this packet for $99 and you'll be free and clear. And you really don't know if that's true. And attorneys like me, in the many groups I'm in, we love those packets online because we always have to unravel them for families. Now, I'm not one of those people that just has blood, in my mouth looking for what else I can get. That's not me, but I'm telling you that is really a thing. And so I want to encourage you not to do that, or if you're going to do it, by all means, consult with an attorney. Okay. Now, to the question that's in the chat, it says, can you put a home in a trust if it has an active mortgage? Yes. Yes. although there are rules around transferring ownership of a property when it is encumbered by a mortgage, in every other situation that may advance the mortgage, that is not the case for trust. So yes, you can put a property in trust even though there is a mortgage in place, and it can be an irrevocable trust or a revocable trust. What the bank cares about is that the owner is still has a part in the trust. So are you the settlor? Yes, most times. Are you a beneficiary? Are you the trustee? Those are the things that matter. But putting in a trust by itself will not advance the mortgage and in no way complicates things as far as that is concerned. Okay. So I hope I answered your question, those few questions that are there. Okay, real quick, the price, and we're almost at our end. Depending on attorneys and where you go, the documents can range from $500 to $1,500 per document. There are many attorneys who offer packages that will have all of the documents, and that may range somewhere between $2,500 to and up, $20,000. Sometimes there are more complicated estates. Sometimes there's multiple properties and multiple deeds and all sorts of things. Trust by themselves often will range between 3,500 and 15,000. That's probably even a bigger range now. When I started, one of the very first estate planning documents I did was a special needs trust for somebody whose attorney had died and who had started the process. And she came to me, she knew I was a young attorney. She showed me the trust that he began drafting and she asked me to finish it, which I did. She paid me $5,000. That was when I first started to do this special needs trust. But he was going to charge her double that. And that was nearly 10 years ago. So I know that the price can go up from there. Okay. Yes. Another question I just got in the chat. Can a trust be added to your estate plan at any time? Absolutely. Yes. And it can be, depending on what kind of trust you want, it would determine whether or not we update your other documents. But it would just be an update to your documents to say, I have a trust now, okay? But you don't have to necessarily redo everything. That is determined on a case-by-case basis. A trust can be added at any time in as long as you're living in your estate process. So if you already have a plan, but you want to make it broader by adding a trust, by all means, you can do that as well, okay? And we are at the end of our time. That is all for now. So I'm going to stop my share, but if you have any additional questions, feel free to put them in the chat or let me know now. Any comments? And I just decided for now, the people who are going to watch this on YouTube or wherever else I may post it, hi, God bless you. Happy Valentine's Day. You probably won't watch it on Valentine's. Maybe you will, who knows? I'm happy that you are watching. But for those of you who are here in my Zoom live, I have decided that everybody in my Zoom room is getting a Starbucks gift card for staying until the end. Thank you so, so much for your attendance. Bonnie, I'm going to just give you a little extra on top since you won the Kahoot. Thank you, everybody, for attending. If you can please message me with your email addresses, I will get that sent out to everybody as soon as this is over. Thank you again for your attention. I'm gonna put my email in the chat. Most of you already have it, but I'm gonna put it in there now. Please make a copy of it and email to me your email or cell phone number, whichever you prefer, to receive your gift card, and you will get it in the next 10 minutes. Thank y'all so much for coming. Thank you for your attention. I hope it was helpful and that you learned something, and I can't wait to see you and talk to you again. Take care.